Hello everyone, we have a little bit of news today regarding two actual small wins in the California Ninth Circuit. These are being brought to us by Firearms Policy Coalition, and I would like to just give you a very short overview of what's going on. This is not a massive event, but it is a good thing to have small wins like this that stack up for future court cases. The Firearms Policy Coalition announced two important victories in the Ninth Circuit in the cases challenging the orders of closure due to a current event going on right now in Ventura and Los Angeles counties. In the decisions issued this morning, the court ruled that the forced closure of gun stores and shooting ranges in 2020 violated the Second Amendment. These are opinions from McDougal versus Ventura County and Martinez versus Villanueva, the LA County Sheriff. These can be found at fbclaw.org. I'm going to have those links down below. The orders therefore wholly prevented law-abiding citizens in the county from realizing their right to keep and bear arms, both by prohibiting access to acquiring any firearm and ammunition and barring practice at ranges with any firearms currently owned. Judge Van Dyke wrote in the court in McDougal, "These blanket prohibitions on access and practice clearly burden conduct protected by the Second Amendment and fail under both strict and intermediate scrutiny." Now, the LA one was only for 11 days, which turns into about 21 is what I believe he also said regarding the 10-day waiting periods, and the Ventura County was for 48 days. These court cases are important because it does, at one extra level, show that the Second Amendment has been proven in certain courts to be a right. And if you take away the ability for gun stores to be open, or if you burden the ability for people to practice with those firearms, that would be considered unconstitutional. I'm saying these things that many of you that already watch these videos probably agree with, but we just kind of have these discussions. Could these court cases go back down to the district courts? Most likely. I think that that's a huge possibility, but it's also possible that these get heard en banc by the Ninth Circuit, meaning a larger panel of judges instead of just the three at the Ninth Circuit. So it could go one of two ways. We could see a situation where damages have to be paid to potential gun owners or the gun stores that were forced to close. We could also see a situation where the Ninth Circuit en banc panel hears it, and then we all know how the Ninth Circus is. The Ninth Circus en banc panel is likely going to say, no, yeah, the point's moot because the gun stores are open. It doesn't matter anymore. Just kick it on down the road. Guns don't matter. Guns aren't a right. We will see how it goes. This isn't a huge thing, but it is a other thing. If this does go to the Supreme Court, it seems like a pretty easy win if it doesn't just get completely dismissed. Could things like this have other value to other Second Amendment court cases in the future? Yes. If some sort of standard is set, or if some sort of new reasoning and rationale is set by decisions that are finalized, that could lead to situations where people aren't able to infringe on your rights in certain ways. This could be very relevant with San Jose and what's going on there. I will be making a video on that shortly, probably in the next day or so. Next week, we're going to need a lot of people to call in to San Jose and try to stop it. You guys know the drill. Have fun, be safe, stay dangerous. Peace. I was wearing these just to get used to it on my head. That's why I'm wearing them in the video. I'm trying to get reps in here and there, because if you don't get used to it, if you then take it out and you're not used to that kind of weight on your head, it gets kind of sore the next day. So adding reps, adding time, it's not a bad idea. Thank you.